Hello, landlords. This is Ernie Garcia, landlord attorney. Today's topic, my tenants left without paying what they owe. So how can I go after them? We're talking about the tenants who got away owing money. And you're thinking, hey, there's all sorts of cash that's left owed to me. I've got a contract. They signed an agreement. How do I get my money? Today, we're going to talk about that. I welcome all of you who are joining. I'm looking very forward to talking to you today. I've got questions that I want to answer for you that have been presented to me. Again, we always talk about the two ways that you can send in questions. Either you're a member of our Facebook group or you are on our mailing list and you want to, reach out to us directly and say, look, I've got a question. I'd like for you to address that in your YouTube Live. Along the bottom of the screen, you'll see our email address and phone number. You're free to reach us that way if you want to join that mailing list. For those of you who are part of Texas Landlords, our Facebook group, we post there continually. Almost 9,000 real estate investors, property managers, and landlords join there, share information, ask questions, and essentially serve as a vital asset to each other. We add our own, legal responses there whenever we get questions. But we also offer this avenue for landlords to ask their questions and get involved. We certainly want people to, learn about what their rights are and, how we can serve them. And one way that we do that is by opening up these lines of communication between our office and you. This live is another opportunity that you have to reach out to me and kind of join the conversation. So if you are interested and have not sent in a question ahead of time, I've got those right here. But if you haven't done it, I want you to feel comfortable joining the chat. Here we go. We've got somebody already on. As always, thank you so much. Great to see you. Those of you who are joining in, I want you to be able to, contribute your questions to me, and I'll do my best to give you an answer. Now, so I'm an attorney licensed in the state of Texas. My firm practices all over the state. We handle various landlord-tenant related issues. And so if you've got a question, I want to help you out. Now, we're going to get to the topic in a second, but we've got a question right here. A tenant of mine wanted me to turn off their heater, but I'm not comfortable doing that just yet. Any advice? Well, the question is, what harm could come if you turned off the heater? Is there some issue that the heater is causing, or is the heater functioning properly? What I might do where you is, if there is a problem, get it inspected and make sure that it is up and running in good order. And then if they say, I don't want to use it, get them to acknowledge that in writing, that for whatever reason they want this turned off. You've established that the heater is in good working order, but they are electing to turn it off. And the reason I would do that is in the event they later try to spring something on you based on what was only present in oral communication. So if you get this written down, I checked it out, works fine, you want it off, not a problem, but make sure they sign off on something where they are acknowledging that you've gone in, verified that the heater is working, but they have elected to get it turned off. If you're asking me what I think, that's probably your best bet. Hey, thanks for being here today. Absolutely, I'm happy to be here every Wednesday, 4 o'clock Houston time. For those of you who can join, whenever we have to cancel, and certainly during the holidays, we took a couple of weeks off. But my goal is to be here as many Wednesdays as I can at 4 o'clock Houston time, and I'm happy to help you guys out. Let's see, working as it is new, they are space heaters. They use space heaters. Space heaters themselves have a risk. There's always a fire hazard as opposed to central air and heating. And so if they simply want the space heaters removed, well, certainly those can be removed if they are not interested. I figured something in writing would cover it. Thanks. Yeah, writing is always going to protect you, so that it's clear in the future if they change their mind or suddenly forget what they asked of you. And so these are the types of questions that we get asked, and I try to answer all the time. I'm going to jump into today's topic. And so if questions come to you, please do not hesitate to post it. I definitely want to get to it. And but before we do that, I want to go into today's topic, which is my tenants left without paying what they owe. So how can I go after them? And so I want to talk to you about the viability of a claim that you would have after the fact. And it comes in different levels and it comes in different fashions. So I want to be able to give you some good advice. So that's today's topic. My tenants left without paying. I want to go after them. They owe me cash. So what can be done? Obviously, the first thing you can do is you can deduct from the security deposit. Now, a lot of landlords are a bit squeamish when it comes to security deposit, but that security deposit is your safety net. If you're not collecting a security deposit and you're not collecting 100% of it right up front, you're kind of opening the door for this kind of situation, because it does happen. They just pack up and hit the road. The tenant walks out owing you money, and that's completely preventable. So make sure not only that you're taking a security deposit, but you're taking it up front. And again, this is a rule of thumb. It's at least 1 month. If you've got somebody on shaky ground, maybe you're taking a 2-month security deposit, but you want to make sure that you're protected in the event that your tenant leaves and they owe you money at that time. Now, if it turns out that the security deposit covers it over and above, well, then you're issuing a refund. But typically, I get this question because either there was no security deposit or it was an insufficient security deposit to cover the amounts that are presently owed. So if you find yourself in a situation where the security deposit the deposit just doesn't cover it, they left multiple months, they left thousands in damage, they had a ton of fees, what do you do? Well, you still do have a few options, and the obvious one is you sue them. You go after them. But I always give landlords a 2-pronged test whenever we talk about a lawsuit. And those prongs are very simple. Number one, do you even know where they went? Because if they're not in the same city or the same county or the same state anymore, heck, they might be outside of the country, it's going to be nearly impossible for you to catch up to them and serve them with a lawsuit and actually be able to collect on a judgment, even if you've got a rock solid claim. So your first question is, if I want to sue them, or if I'm thinking about suing them, can I even find them? Do I know where they are? Now, you don't necessarily have to know where they live. You might only know where they work, and that's fine. You just have to be able to physically locate them so that a process server or a constable or a sheriff can put that lawsuit in their hands and they can be properly notified of a lawsuit. But the second question is also important. That second question has all to do with whether you've got a reasonable expectation that you'll be able to recover from this tenant the amount of your lawsuit, because it doesn't help you if you sue them and you can't ultimately collect. So if you're going to choose to sue, can you find them and can you ultimately collect? And so we've talked about the issue of them having enough security deposit. If they don't have enough, then you go after and sue them. Your other option is to report them to credit bureaus. But what you're likely going to find is you're probably not a big enough fish to do this. Reporting is usually something that's reserved for bigger outfits, like apartment complexes that can afford the cost of such a mechanism. So, apartment complexes can often do this in ways that owners of single-family homes just can't, and so reporting them is possible, but it's harder for a landlord of single-family homes to do. One way to report them is to take a judgment and establish a judgment lien. So if you have sued one of your tenants, it is possible to create a judgment lien against them by abstracting your judgment and recording it with the property clerk's records. And what I always tell landlords is you're going to need some identifying information. Typically, it's the last three in the state of Texas anyway, the last three of their social, the last three of their Texas driver's license, and their date of birth. These bits of data, when your abstract of judgment is formed, help to serve as proper identification because of the low likelihood that someone with the exact name also has the last three of their social security number, the last three of their driver's license, and the same date of birth. And so you'll be able to narrow down when you sue, John Brown, there's going to be a million of those, but you can narrow down to the John Brown that you are suing by these last three and the date of birth. So you want to report them, but then you also might think, well, how about sending the matter to collections? I hear a lot of landlords who talk about, well, I'll just send it to collections. I know a collection agency, I'll send my debt there. And certainly that's a viable option. Without a lawsuit, your debt will last and is collectible for up to 4 years. Now, if you sue and get a judgment, in the state of Texas, you can make that judgment last really indefinitely, but without a judgment, without a lawsuit, you've got about 4 years. That's your statute of limitations. And if you've got a good collection agency that can, go out and collect that money for you, maybe you pay a certain percentage for what they do collect, that's great. However, in my experience, I have seen very, very little in terms of, viable, fruitful options when it comes to collecting debts this way. I don't know of a single debt collection company that has worked to effectively, bring in, a substantial amount of money for a landlord. So do I, tend to recommend this option? I actually don't. Maybe there's a company out there that does successfully collect, unpaid balances. If that's happening, I'm definitely interested in hearing it. But in my 15 years, I've never once had the occasion where a debt collection company actually made good and collected a substantial amount for any landlord that I ever represented. So that's not one that I've heard has a pretty good, strong effect. But the last one is the one that nobody wants to hear, but it may be the truest thing and the most important thing for you to hear. You might just want to forget the whole thing because it's just not worth your time to go after a deadbeat tenant who's never going to pay. And so you, again, make this decision to sue them or not sue them and decide, look, I made a bad call. I let in a tenant. Maybe my screening mechanism wasn't great, or maybe I just cut them way too many chances. It's an expensive life lesson, but it's like a semester at college. The things you learn, and it's sometimes as expensive as a semester in college, but the lessons you learn from it are valuable, even if you're unable to collect the literal value that you've lost from a particular tenant. You may just decide, look, expensive life lesson, I'm going to learn to do better in the future. And hopefully it does teach you to do things better. Screen better, evict faster, send notice, prepare your tenants ahead of time before the losses are incurred to minimize your losses. You're collecting a legitimate, adequate security deposit to make sure that if these problems do surface, you are protected. So, hopefully you don't find yourself in this situation, but chances are if you do this long enough and have enough rental property, you're going to be in a situation where you have a tenant who just walks out and doesn't pay their full balance. Do your best to get ahead of it, prepare for it, and then act quickly in response to it. So there we go. Those were that was our topic for today. Next week's topic will be if tenants are harmed due to bad weather, and we're having some of that here. It wasn't nearly as cataclysmic as all the weather people said it might be, but if your tenants are harmed due to bad weather. How much liability falls on you, the landlord? We're going to talk about this next week. Don't go asking questions on the live stream because we're saving that one for later. But for those of you who do have questions, I want to get to them. So here we go. We got an update. Won my trial Thursday. Defendant didn't appeal, filed writ, and constable delivered 24-hour notice today. What can I do if she leaves all her stuff? Should I have a moving crew ready? Thanks. A couple of things, because this is a common question, and I get landlords who they're ready to jump in. The 24-hour notice was there. The tenant leaves or appears to have left, but they left a bunch of stuff behind. Well, you're kind of not ready yet to really jump in and really take full control again yet. And so what I'm going to recommend that you do is the following. First, take a look at what your lease says about abandonment. If you've got an abandonment clause and a procedure established in your lease, follow that procedure. I'm going to give you an example of what some leases already say about abandonment and how to handle it. So your lease might say something to the following effect. If in my reasonable estimation as a landlord, I believe you and everybody else have vacated the premises. That's check one. Reasonable estimation, everybody's gone. And you might get this, for example, maybe all the beds are gone, but they left a bunch of other stuff. All the clothing is gone, but they left a bunch of other stuff. Maybe the utilities are turned off, but they left a bunch of other stuff in the unit. So in your reasonable estimation, they're out. Second, you're in default. You owe me rent. You have not paid, and it looks like you've left. The third stipulation is, I've left a notice for you to come and get your stuff within the next 48 hours or something like it, depending on your lease. And since you haven't, I'm declaring everything abandoned and I'm tossing it because your lease says that I can. Now, I don't know what your lease says. Your lease might say something totally different. It may not have an abandonment provision in it, or its provisions might be a little bit different. But this is kind of an example of what you could do. So when you have that suspicion that they vacated, you know that they owe you rent and their stuff is there, but you're not sure whether they've left it behind or not for you to discard. You're going to leave a notice for them. And what I tell landlords all the time is, while your lease might say you're going to post it on the door, I would say get this notice to your tenant in every conceivable way possible. Business email, personal email, mom, dad, baby bear, everybody gets an email. If you know it, if it's connected to your lease, send it. I would even mail a copy of that notice to the premises. And you're saying, well, Ernie, they don't live there anymore. They'll never get this mail. Well, it might actually get forwarded to their forwarding address if they've set that up with a USPS. And you're going to know if that letter never arrives to the rental property. And so you just want to make sure that you've taken every reasonable step to contact them and say, as of today, I think you're gone. If you don't reach out to me in 48 hours and come and get your stuff, I'm going to declare it abandoned, and per the lease, I'm going to discard it in any way that I see fit. By sending this notice in these multiple ways, here's the procedure that I would suggest. If you sent the notice today, wait tomorrow and the next day. Those are 2 full days. And then the following day, and then maybe a couple more days after that, so that if they ever come up with a claim and say, what? You got rid of my stuff? Did you throw away that side table where grandmother's $25,000 brooch was? I meant to come back for that. You owe me $25,000. Well, the response to that would be, no, I don't. I follow the procedure that you agreed to in this lease, which said, if I gave you notice in this way, and I gave you notice in many more ways than that I could discard of this stuff as abandoned. You follow that procedure and then some, you'll be able to demonstrate to a court that you acted in a more than reasonable manner, and boom, no liability. So that's what I would suggest, especially if the constables aren't going to come to execute this writ for another week or so. You can maybe get ahead of it if that's in your lease and you conduct this procedure appropriately. So I hope that helps. Curious to hear your reply. In 12 years as a property manager, I've only had 2 tenants stop paying rent, both resulting about $20,000 in losses to the landlord. Is this a normal expense? Well, no, not usually. That's a lot of money. So yeah, if it's going to depend entirely on how long the tenants went without paying. I mean, if it's $1,000 a month and they went 20 months without paying, somebody fell asleep at the wheel. But if the rent is, say, $5,000 a month and they went 4 total months without payment, well, that might lead to the question of viability of collection. Because if these tenants could afford a $5,000 a month rent, and there are tenants out there who are paying that amount or more, then maybe they still have the capacity to pay. They just weren't willing to pay. Or maybe they own assets that you could potentially seize if you had a judgment lien against them. So these are considerations for sure that you could consider, but I would need to know a few more facts. Certainly a tenant that has a good job or owns significant assets. I'll tell you, one significant asset in particular would be multiple vehicles. And so the law allows them to maintain one vehicle titled in their name, but if they have 2, that second vehicle is subject to seizure. And so if that vehicle can be seized and sold at a police auction, then yeah, its proceeds can be used to pay off a judgment if you've established a proper judgment lien. So hopefully that helps. Let's see. You are a light of hope for all us stressed out landlords. Your positive attitude is just as helpful as the legal expertise. Can't thank you enough. Well, you are very welcome. I do what I can to try to help. I hope these recommendations are helpful, and I appreciate your kind words. That's always very nice to hear. Thank you. So let's go on to one of our questions. Boom. Per the lease contract, this is from Jose Lira. Per the lease contract, the tenant is to give 30-day written notice of non-renewal. So what this tells me is we're coming to the end of a lease, and the lease requires, if you're not going to renew, you got to tell me with at least 30 days. Otherwise, this lease agreement automatically renews on a 30-day or a month-to-month or some other basis. It kind of sounds like it would otherwise renew month-to-month. But let's proceed. But tenant only gave 10 days verbal notice. So I would say if the lease requires written notice, no notice was actually given. Due to this, can the landlord deduct from the deposit the period for vacancy up until it is rented? On the contrary to this question, if the tenant does give a 30-day written notice, then landlord is not allowed to deduct the period for vacancy up until it's rented. Please help clear this up. So I'm going to answer the second question first. If proper notice is given in advance, and you get at least 30-day notice, hey, I'm not renewing, and they pack up and they go, then nope, there's no way to charge them any additional fees for rent because they're not renting from you anymore. They brought their lease to an end. They terminated it in accordance with the agreement. And so no, unless they're there, they owe no additional funds, even if it takes you 15 months to find a new tenant. Now back to question 1. So there was definitely defective notice. But let's say the tenant left at the last day of the lease term without giving, or in this case, having given defective notice. So defective notice is essentially non-notice. They just left. How much money do they owe the landlord? Well, it's going to depend on what the landlord does to mitigate his or her damages. Because it's not enough that it took the landlord multiple months to find a new tenant. The landlord's going to have to demonstrate, and this is always the case for a situation like this, the landlord is going to have to demonstrate that they acted in good faith and they took reasonable steps to find a new tenant. However, remember that the tenancy is only extended for 30 days. The moment the tenant leaves, there isn't some open-ended extension to the lease for all of eternity. Instead, you can viably say, at most, you're entitled to 30 days, because by operation of surrendering the property back to the landlord, they have given you adequate notice that they don't intend to renew. So you can't say, well, I had no idea they weren't going to renew. Yeah, you did. Yeah, you did. And so then the onus falls to the landlord to, within that 30-day period, find a tenant as quickly as possible. And if through every good faith effort of the landlord, he or she is unable to secure a new tenant, well, their damage calculation ends at the 30 days, right? So at most, you're talking about 30 days for a residential tenancy, unless 60 days notice or 90 days notice was required. Whatever that, and the fact pattern that I was given here, it appears that it's a 30-day notice. So the maximum that you could essentially shift the burden onto the tenant for would be 30 days. Again, even if it takes 15 months to find a new tenant, you're capped at 30 days, because that's all really you were entitled to, was 30 days of notice. And you can't say you did not know, even if written notice was required. I can't see a court extending it indefinitely just because written notice wasn't required after possession was surrendered to the landlord. Now, this is different than if a tenant leaves in the middle of a lease. If a tenant leaves with 5 months left and the landlord takes 3 months to finally find a new tenant, well, they can't charge all 5 months because the law requires them to mitigate their damages. But if it took 3 months to find a new tenant and there were 5 months left on the lease, yes, the maximum that landlord can charge that out, the previous tenant, is the 3 months. But in the interim, yeah, the tenant continues to owe all the way through the end of the term until the landlord mitigates their damages. And again, they got to show good faith. They got to show that they were taking reasonable steps to find a new tenant. If they can do that, then yeah, they've got a viable claim. I hope that answers you. Here we have an anonymous question. We've got a few today, anonymous ones. How can I protect appliances from theft from any potential tenants? I believe this is a brand new landlord who asked about protecting against theft from potential tenants. And we talked about this a little bit. One viable way is to take an adequate security deposit. Another, if you're unsure about the kinds of tenants you're putting into your rental units, do a thorough background check on them. Find out what they did to their previous, maybe 2 or 3 landlords if you're worried about the threat of them stealing appliances. The other is, again, if you have a legitimate worry about this, don't use brand new appliances. If in your rental you use used appliances only, they still work, but they have a lesser dollar value. That's another way you can protect yourself. And so higher security deposits, better screening, lower value appliances. But ultimately, you can't protect against criminal acts except maybe your last option would be through insurance. And so if you've got a lot of very expensive equipment in your home, you're gonna, and this is just good practice either way, you're gonna wanna be protected against theft and vandalism. So make sure that you've got, as part of your insurance, coverage for these sorts of things, especially if you have a lot of expensive equipment to replace if your tenant ever stole your appliances. Which happens from time to time, but I just don't hear it happen a lot. It is a potential thing, but you have ways to protect against it. Again, good screening, adequate security deposits, insurance, and then again, just lesser expensive models if none of those things still make you feel particularly safe. Another anonymous one here. Can a tenant request major repairs the day the landlord raises the rent, even though no major issues have been reported? Well, the very straightforward answer is, yeah, a tenant can raise major repairs at any time. The question is this a legitimate repair request? And so, if a tenant is saying, well, then you need to update the blinds and you need to redo these floors and that roof was looking a little saggy. Again, unless there's a defect on the premises that materially affects the health or the safety of an individual, it's unlikely that they can force you to do, purely cosmetic upgrades to the unit. But if there is a legitimate safety or health concern, then yeah, they can ask for that at any time, whether you raise the rent or not. And so, yeah, be wary of that fact, but also be conscious of the fact that a tenant may, kind of retaliate against you for raising the rent and suddenly demand that you make all these repairs. None of that is actionable unless, again, in the state of Texas, there's a defect that materially affects the health or safety of an ordinary tenant. Again, purely cosmetic repairs can't simply be required by the tenant at any time. And so the fact that you've raised rent, if you did it according to your lease and in accordance with the law in terms of notice, that doesn't open the door for, repairs necessarily. The standard has to be that the defect has a material effect on their health or safety. So, and this question: if a tenant makes a hole to hang pictures, is it considered normal wear and tear? Do I subtract it from the deposit? I think this is a great question, particularly from newer landlords, because if you've never rented space before, it's hard for you to know what the normal tenant does in terms of, affecting the space. But I can tell you that, most, nails to hang pictures are normal and they will do damage. And so what's important for you to understand is that tenants are allowed to damage your property in a normal way. And so now, if you have a complete ban on holes in the wall, let's say that you've set things up and you have built-in shelves on all of the walls so that people can place pictures there, and your lease prohibits nails in the wall. Well, then a person who does put nails in the wall is not acting in normal course. But generally speaking, it is presumed, unless it is prohibited, that holes in the wall from nails to hang pictures is perfectly normal. You're not going to find many courts who would see things otherwise. Again, unless the lease prohibits it, and your lease might, you probably aren't going to be able to charge your tenant if they put holes in the wall in a normal and ordinary fashion. And hanging pictures, perfectly normal. If you want a way around it, you could put up shelving. You could require, specific things. And I'll tell you one that is pretty easy and pretty straightforward and might save you a lot of money is a prohibition on hanging televisions on the wall. I've seen so many tenants who do this poorly. Like they're not handy themselves. They figure out some way and they end up putting gashes in walls or knocking gigantic holes in the walls. And yeah, that's not ordinary. That's not normal. And you may want to prohibit the installation of televisions on the walls without your consent. And you may say, look, I've got a guy, my handyman will go in and install your TV for you. And that way I know that it's done well and that it's not harmed. Now, the risk that you have there is that your handyman comes and he breaks the TV or something happens and it's loose and bloop, the TV falls and now you've got a potential claim. But another way around that is to say, look, I'm going to give you written permission, but you agree to return the wall to its prior state, which means you agree to repair it, or you agree that if in removal of your TV, you cause damage to the wall, that you'll cover those damages. And so there are ways around it in terms of, completely banning nails. But with things like television installations, I'd be cautious about, just blanketly giving permission. I would definitely want the opportunity to discuss that with the tenant and approve any kind of installation like that they plan to do, and not just give them carte blanche when it comes to hanging televisions or hanging, art on the wall of a substantial weight, right? If you've got a big old thing that's going to cause a damage to the wall, you're probably going to want to reconsider. You're definitely going to want to give them notice. Hey, look, anything above this size, I need to know that you're going to hang it on the wall because that would not constitute normal use. So if you want to get in on it, you definitely can. You can be very specific in your house rules as to what can or cannot be hung up, what can or cannot be installed. And I would be specific if you have a strict prohibition on certain things like pictures and televisions. So guys, I appreciate you, those of you who hung around. This was a short one today. I didn't get a whole lot of questions. We did get some on the chat. Again, I want to show you what we're talking about next week. Next week's topic, if tenants are harmed due to bad weather, how much liability falls on the landlord? We're going to dig deep into that one. I'm going to give you what I think or how I would advise a client in these situations. And I look forward to seeing you guys next week. I hope you all have a wonderful week. Enjoy the rest of your Wednesday afternoon. And until next time, landlords, have a rocking good time. Thanks for answering your question, Ernie. You are very welcome. You guys have a good one. I'll see you next Wednesday.